thank you so much for joining us for the Beyond Estate Planning workshop today. Our guest, Doug Martinson. Doug is going to introduce himself because he has so much of a huge resume. I'd rather him say it than me because I will leave something out. We are going to have a Q&A as this is at the end. And our objective here is we've got our camera crew here to tape this for beneficiaries. Thrilled to have a couple of children in the room to do some family planning and sort of spread the good word. So without further ado, Doug.
All right, thanks, Shari.
Bring it on.
All right, so they told me to stand in the light, so I'll try to stand over here. All right, I'm Doug Martinson, and I'm from Huntsville, and I've been practicing since 1990. My grandfather started the law firm in 1937 when he graduated from high school, and he didn't go to college, but he read for the bar, so you could take an exchange student, read for the bar, and then get your law license.
Really? I didn't know that. That's awesome.
So then he was actually, the story was he was a butcher's assistant at the A&P and also delivering some meat or groceries, and he came back and the telegram came in and the guy announced that, he said, well, my butcher or delivery boy's now my lawyer, so I introduced him.
That's scary.
But then, so I was born my dad's third year of law school in Tuscaloosa, and then moved here when I was about 6 months old and lived here. And I have a brother that practices with us. We have a personal injury attorney. We also have Raina Bauer, who's here. She started with us last year. She's been here about 7 months, just graduated from Alabama and went to Alabama undergraduate. Then my son, Clay, is now the fourth generation, and he practices with us, does a lot of litigation and trust litigation, contested estates, and breach of fiduciary duty. And my brother does real estate law. And we do have one person that does criminal and divorce. Hopefully nobody has to go see them. But anyway, they're there if you need them. But I primarily work with probate and estate planning, avoiding probate, and then also doing a lot of guardianship conservatorships. I've been the county guardian and conservator, which used to nobody knew until you had Britney Spears and a few other high-profile cases. So now then I can say that, oh, okay, I know a little bit about it. Although, unfortunately, my people don't have, $50 million and travel around singing all the time. But so I get a lot of people who are indigent, who are at Huntsville Hospital, who you have to get placed in nursing homes and then sell their assets, or people are being taken advantage of. And we see a lot of elder exploitation. And at the end, I'll touch on that because anytime I speak at a group, I like to put everybody on notice of all the scams, and I'm sure you get them. I'm sure you get the notifications on your phone. Hey, we haven't seen you in a while. What are you up to? That's not somebody that knows you or anything. They're trying to get information. But so what I'll start with is we'll go, start a little bit with the presentation, and it's in your packet, but it's up here, and you can look at that later. But generally talk about what is an estate plan. So there's several different types of estate plan, and it depends on your situation. It depends on your family or your assets, where your assets are located. If you have a farm in Tennessee or a house in Florida or a beach house or a property in another state, you may need a different type of estate plan, like a revocable trust. If you have children who are special needs, you may have to have a special needs trust. And then also if you have children that are minors that you need to protect, or grandchildren, so you can have trust to protect them to where they have income for their life or their for their education. So really an estate plan, a lot of times the general documents are a will, last will and testament, power of attorney. There's a durable power of attorney for finances, so you can appoint somebody who you want to be in charge of your affairs. Most of the time, it's where you become elderly. If you don't, and you have dementia, you want to appoint someone to take care of those affairs to avoid a guardianship conservatorship. But there's a health care power of attorney where you can appoint someone to make health care decisions for you. Typically, a husband and wife, the spouse would be able to make those decisions. But if something happens to both of you or one of you where you can't act, it's good to have somebody else named to make those decisions. And then you can also have an advance directive for health care. And that's the living will, where you state whether or not you want to have life-sustaining treatment. It's just a statement that you make that if you can't speak for yourself, that shows your wishes. So that if two doctors have evaluated you and determined you're terminally ill or injured or you're permanently unconscious, do you want to be kept alive? And also, do you want to have food and water through a tube?
So Doug, on the 4 basic documents, the will, the power of attorney for healthcare, the power of attorney for finances, and the living will, can you comment specifically on the power of attorneys? What is the deal with having an old document?
Right. So the good question is, a lot of banks and financial institutions want a power of attorney dated within the last 5 years. That is not a requirement in the law, but there are several of the credit unions or banks that they want it dated within 5 years, which a lot of times you can't get it. But it is good to have your documents updated, because you may have appointed somebody that's deceased or moved away or disabled, or you don't want them handling your affairs anymore. So it's a good idea to review your documents every 5 years, just in case something has changed or your situation's changed, or just keeping it updated for that fact.
Right, so it's to the financial institution, and not all financial institutions have all the same policies, right? And so you may have done a power of attorney in the past and you've got it checked in your brain, okay, I'm good. But a financial institution is actually going to look at it a little bit differently of, wow, if this is an old document, how do I not know as the financial institution that someone else has been named in a later document, therefore I, the financial institution, am at risk? Like, do I really believe that this document from 10 years ago hasn't been superseded with another choice? And so that's why we tell people, keep those documents updated. We had a recent client situation where the majority of assets were with us. There were some assets at a couple of other brokerage places. Those other, one of those places, they took the power of attorney just fine. The other one, they said, and they made them go through all these hoops. So just a good idea to keep those documents current.
Right. Yeah, because you never know what happens, and what if you have an event or something with your family or your heirs or who you put in charge, that's a time to go in and change.
Okay, so let's say you don't have the documents.
Right.
Like, I don't have a will. I don't have these things. What does the state of Alabama say about that?
Right. So if you don't,
and maybe Florida, Georgia, like everybody's got their own law.
So if you don't have a power of attorney and you're incapacitated and you're in the hospital or you're in a nursing home, you have dementia, the only way around that is for somebody to get over your assets, to sell your property, or to get your money, is a conservatorship. And the conservatorships you would really want to avoid if possible, because there's a lot of restrictions. There's a lot of cost regarding reporting, bonding fees, and also it may be somebody that you don't want to be your conservator. Somebody may come in and take over and become your guardian and conservator. It may be the child that you don't want to be in charge. They may, like a lot of times they call them seagulls. They say they usually fly in from the north. They make a lot of noise. They go around. They crap all over the place. They fly home. So, and you do see a lot of that. So it's good that you will not name the seagull as your person. If you don't have a will and you die, you have to. It would be, everybody said, well, the money does not go to the state of Alabama. Only time it would escheat or go to the state of Alabama if there were absolutely no heirs involved. But the state of Alabama will decide who your property goes to, and also who can be your administrator. So if you don't have a will, your spouse would have first rights to be the executor or administrator. And then the children would, but they have to live in Alabama. So if you die with no spouse and your children live in Tennessee or Florida or Seattle, wherever, they cannot be the administrator. So it has to be someone in Alabama, because they have to be bonded and report to the court. So not only do they have to live here, they have to be bonded, they have to file an inventory, and there's a lot of different fees in it. And if you have minor heirs, so if you have minor children or if you have a child that has died leaving minor grandchildren, they are heirs at law, and the court would have to appoint a guardian ad litem, which is an attorney to represent them, just to make sure everything's in their best interest and proper.
Cha-ching, cha-ching, cha-ching.
But yeah, so they have those. So you can have a will that appoints an executor, whoever you want, wherever they live, and you can waive the bond and you can waive the requirement of filing an inventory. And then, but the will does have to be probated. A lot of people said, well, my will says it doesn't have to be probated, but unless it's probated, you don't know who's in charge. So you could nominate somebody, you could nominate your wife, your daughter, or whoever, and then if you've just nominated him, so the court has to appoint it. So probate means to prove. So you have to prove that that is the last will and testament, and it's the true last will and testament. And the only way to prove that is to file it in probate, notify anyone who would take under the estate if you didn't have a will. So notify the heirs at law, and then they have a chance to come in and contest it, or to come in and also file claims against the estate. But that's what the probate process is. And then there's a 6-month claim period for anybody to file a claim against the estate or to contest the will. And a lot of people say, oh, well, if I want to cut my son out, I'll leave him $1. And you don't have to do that. The bad thing is at the end, you have to prove that you gave him the $1, or you have to have a hearing. So, but you don't have to leave somebody $1 or whatever. But the other thing is, so a lot of questions we get is, do I need a trust? And a lot of people say, well, I don't think I have enough assets to have a trust. But if your assets are, if you have a house or real estate, even all in Alabama, and you live in Alabama, a trust can avoid probate. So there's a lot of times there's a lot of situations where you do want to avoid probate. If you are, you're favoring one child or one beneficiary over the other, or if you don't have children, or it would go to, your brothers and sisters may come in and be part of the estate if your parents are deceased as heirs at law. Or if you have second marriages, you want to have a trust that's set up to where the trust determines what you want to do. Or if you have special needs children or minor children, or the property in other states. So if you had property in Alabama and you live here, but you have a farm in Tennessee or a beach house in Florida or inherited property in North Carolina, you'll have to probate the estate here. And then you have to do what's called an ancillary probate. An ancillary means you have to have a probate here, a probate in Florida, and a probate wherever your property is.
And so that's huge.
Yes.
Like to go through 3 different probates. One, if you just had that trust, and if the trust owned, say, the property title to the Alabama house and the Tennessee house and the, XYZ, then the probate would be waived because the trust terms would determine where the property goes. So that's another biggie of, I may not feel like I have a lot of money, but if that money, if I have a $100,000 condo in 3 states, you're going to go through 3 probates.
Right. Yeah, and a lot of times, the trust, a lot of people, as I always say, it works better in practice than in theory because, what's a trust? And it's hard to wrap your mind around what a trust is, but a trust is really a legal document, just like a will is, except the trust, they call them inter vivos or living trust. So you set it up during your lifetime and it's revocable. So you can change it. You have complete control over it. You don't get a new taxpayer ID number. So let's just say that you have the trust. You set the trust up. You can be the trustee. You can be complete control over it. And then you say that if I am incapacitated or at my death, I appoint my son, my daughter, whoever you want to, and then they would take over. And then, so once you set the trust up, the other thing is funding the trust. So a lot of people set up the trust, but they don't get all of the assets into the trust. But the funding's not that hard, so we can do the deed. So we could go online, we could get the deed from the Madison County or anywhere in Alabama and deed an Alabama property to the trust.
But we've got people all over the place. So how would we get property deeded if it was in another state?
Right. So if you had the beach house or the farm, you would go to an attorney in that county or in that state, and then they would just deed that property into the trust, and it would be filed in Tennessee or what state that is. and then you can sell that property at any time you want. So let's just say you transfer your house to the trust and you want to move. You will sign as the trustee selling the house. The money will come to the trust, which you're the trust. It'll go in a bank account you're in complete control over. And then you go buy a new house and put it in the trust. A lot of times people will go buy the house and they don't, they put it in their names and you have to transfer it to the trust. But anything, the trust is going to govern anything that's in the trust. And then for your financial assets, you could go to your financial advisor and they just change the name from you individually to the trust. And then y'all are the trustees. Something happens to y'all, so let's just say that you have to go to the nursing home. There's a HIPAA waiver to where the trustee can go to the doctor to determine that you're incapacitated, so they could show the financial advisor or show the real estate closing attorney that you're incapacitated and that the successor trustee needs to take over, and they can sell the property. And then at death, there's no probate because they go in and they will sign a certification that they're the trustee. The trust was created on April 30th, 2026. Here's the trustee, and then that's all they need, and they can sell that property, and the money goes into the trust. And then the trust is really just a bank account, so it's really just changing the name or the ownership. The other things are with
or brokerage account,
right,
or real estate, or fill in the blank. Right. It's just the titling.
Right,
of
exactly.
it to clarify.
And that's pretty easy because you can go get that done. It just requires you going to the banks or the financial advisor or wherever your assets are. For your retirement plans, most of the time I will recommend that you not put it in the trust unless you have minor beneficiaries or you have beneficiaries that are grandchildren or special needs and you need it to be in the trust. But there's that you may have heard of the Secure Act. It's passed, I think, 2017, and so that's where you have to take the distributions, the required minimum distributions, or distribute all of the money in the retirement plan out within 10 years and be taxed on it. Used to, you could stretch it out until you were 70 and a half, but now then a non-spouse beneficiary has to take it out within 10 years. So it's best if you just name your spouse or whoever you want to name as the primary beneficiary, and then your children or whoever's the secondary beneficiary, and they can put that into an inherited IRA and spread it out over 10 years.
Hey, Doug, that's a good point, talking about the taxes and all of that piece of trusts. And I know, a classic problem that a lot of boomers have, Huntsville's, famous for it, is a lot of the assets that we have are in retirement plans. And so, when those are inherited, by a beneficiary, that's going to be governed, there's going to be this 10-year forced payout, or you got to take the money out over that 10-year period. There was a recent client example, in addition to what you're talking about, that had, a significant portion of their money in an IRA, and there's sort of double taxation going on, but they elected to go ahead, put that IRA in the trust, even though normally you don't do it. But the reason that they did that is they were worried about the divorce of one of the children. And that is a common thing, whether it's an IRA or a non-IRA, that we are seeing more and more, that, we know that divorces are more than, I don't even know the latest statistic, 50% of the population, and then second marriages break up like 75% of the time, and it just gets worse and worse. But if you're worried about, keeping the assets along your family line, then no matter whether it's an IRA or a non-IRA, some conversation really should be had of, do we need one of these at death trusts to spring into action, which they call it the testamentary trust. Do we need that to keep the money in the family name in the event of a divorce from one of the children? So just a little, not an everyday case, but seems like the more money that is showing up in portfolios, the more that becomes sort of a, something that we may want to talk about and think about, just to preserve the family wealth.
All right. Yeah, and most people want to do that. So, and the trust can set that up to where it goes to the, to your son or daughter per stirpes is what it means. That just means by representation. So it would say that if your son died and had 3 children, and you had let's say you had 2 children, and your son died and he had 3 children, his half would be divided into thirds under the per stirpes. And then you could put in there that it stays in trust until the beneficiaries are 25, so that you're not dumping a lot of money on a 19-year-old, which would happen in a conservatorship. Said you'd make a car dealer somewhere, and car sales are very happy, because that is exactly what the first thing that they would do. And I probably would have done the same thing. So, but to have maturity level, and also, I mean, a lot of people want to say, well, I want them to get it at 25, but if you hold it till 30, at least they're out, they're more established. And the trustee, it's not like this money's locked up where they can't pay, that they just have to sit and invest it. They could buy them a car. Might not be the expensive car they want, but they could buy them a car. They could pay for their college, they could pay their education, they could pay for their vacations, or they could pay for trips, and give them an allowance. So you can make the trust a lot of different terms. Some people have incentive trusts, where you say, well, I don't want them to just sit at home and not do anything, so I'll match their W-2 at 50%. At the end of the year, they go in, they show a W-2 of what they worked, and say, okay, well, we'll give you 50% or double it or whatever. Or they have a daughter that they would like to stay at home, they may have some trust to where the daughter could be provided for childcare and other things. So there's a lot of different things you can do in the area of the trust, whether it's in a will or it's in the living trust. But even if you just have property in Alabama, the living trusts really work well, because you're avoiding probate. So, probate, like I said, you have to notify the heirs at law. You have to put notice in a newspaper. There's a 6-month claim period. There's for people to file claims against the estate or to contest the will. And then you got a delay. If you sell the house, the real estate closing attorney is going to require that money to be in escrow. So it's going to sit there earning no interest, because you can't earn interest in an attorney trust account. So it's going to sit there not earning interest, and then you're just waiting till the end to distribute everything out. So typically it's cheaper to set it up, the trust, now versus at your death. The only thing is you're paying for it now versus your kids paying, or your beneficiaries paying for it at your death.
So that's a good segue. You've covered a couple of different pieces of this. And so it would be nice to sort of spin this and say, what does every beneficiary need to know about probate?
All right. Okay, yeah, so like I said, probate is a 6-month period. You have to find heirs. So and if you, especially if you have children that don't get along, they can go to court. They can try to hold things up. They can not agree to or consent to having the will probated, or somebody's working in Canada or Washington D.C. Or wherever, then that may be an issue of them to sign and then to handle it. So whereas a trust, you just avoid all of that. That step and that expense. And the other thing that beneficiaries should know, I always get the question of what taxes will my heirs have to pay. So a lot of people are going back to the death tax. Well, and the death tax is a very, very nice problem to have, because it doesn't start until $15 million. So a husband and wife can pass $30 million. Under federal death tax.
But it didn't always used to be that way.
Right,
so people talk about it.
Yeah, so when Shari and I started, it was
$600,000.
So, you didn't have, and 600,000 was a lot. It's still a lot, but back then it was a whole lot. But so you had to do all of these crazy planning and do marital bypass trusts and credit shelter trusts. But now then they made the law really easy. One, they stepped it up to 15 million, but in Alabama has no death tax. The other thing is you get what's called a step up in basis. So any assets that someone inherits, so anybody in this room, if you inherit assets or you pass it on to your heirs or your children or whomever, their tax basis is the value at the date of your death. So it's easier to talk about it with stock. Real estate, what's the value of real estate on the date of death? Nobody, I mean, you can get an appraiser that says it, but their guess is as good as, maybe a little bit better than most other people, but maybe not. But stock, so let's just say that you have AT&T stock that you hold now and is trading at $25. Let's say you paid $15 for it. So if you sell that stock now, you have a $10 capital gain. If you give that to your children or you give it to somebody, they're going to take your basis. So if you take that stock that's worth $25 now and you give it to someone, their tax base is at 10. So if they sell it, they have a $10 gain. But if they inherit it by reason of death and you die and it's worth $25 and they sell it for $25, there's a zero tax. They sell it for $30, there's a $5 capital gains tax. If they sell it for $20, there's a $5 capital loss. So that is a big tax advantage in getting the step up in basis, and especially with real estate. So typically, if you inherit real estate and it's and you sell it within a year, it's hard for somebody to go back and say, oh, well, it increased 6% or something like that. So typically, most accountants or CPAs would say, well, there's no taxable gain or it's very minor. But that is a big advantage to beneficiaries that when they inherit it. Now, of course, if they inherit annuities or other taxable, there may be some income tax paid on that, and also with the retirement plan, that's income tax.
And so that's a big planning opportunity that as a financial advisor that we love working with families on, because if we know the parent's situation and we know the children's situation and we know that either one of them, particularly the parents, if they've got a bunch of IRAs, annuities, things that they have not had to pay tax on, when they're inherited, that's a big tax bill that is going to get dumped on that beneficiary. And if the beneficiary is also putting money away in their retirement plans, they got a double trouble. And so if we just know this ahead of time, and we know the magnitude of what might be passed versus what might be accumulated by the beneficiary, we can figure out a more holistic strategy to tackle it to where you're keeping more for you and paying less to Uncle Sam. So that's a huge, huge planning opportunity. And it used to be back in the dark ages when we did start that the beneficiary could take receipt of that IRA over their lifetime. The law has changed, backed that up to where it's a 10-year payout. They're forcing you to take that IRA money over that 10-year period. Annuities, it can go longer, but IRAs, it's going to come out fast. The IRS wants their money.
Yeah. Yeah. And if anybody has charitable intent, if you wanted to leave money to your church, to the Red Cross, the library.
Yeah. Yes, huge.
Yeah, so the best way to do that is not say in your will, I leave $10,000 to my church, because that's just $10,000 that goes to them that would not be taxable. So if you have an IRA, a 401k, or well, not a Roth IRA, because it's not going to be taxable, but if you have a taxable IRA, the best thing to do is to leave that to whatever charity you want. You don't have to leave it all, but you can leave a portion to it. And you can also do that during your lifetime. So if you have highly appreciated assets, you could give that to the charity. And let's go back to the AT&T stock. So you paid $10 or $15 to AT&T stock. It's worth $25. You sell it, you have a $10 capital gain. If you take that $25 stock and you give it to a charity, then you get a tax deduction for the full $25, and you don't have to pay that $10 gain.
And they get the whole thing. They get the whole 25. So that's huge. So.
Yeah, and so that also works at death, and also if you have the required minimum distribution, you can do what's called a QCD, qualified charitable deduction. So you could have your income from the required distribution, because if you took that, so they'll compute based on your age how much you need to take out every year, and you're going to be taxed on it. But if you take that amount and you give it to the charity, whoever you want, you won't be taxed on it.
And so let's just do a little plug there. You've got all year to do it, to take this and make that decision. And just in the nicest of ways, Miss Martha would love for you not to do that on December 1st when all the other reporting is done. So if we could kind of, have that happen a little earlier, it's just a good Christmas present for any of our staff who happens to be processing, your qualified charitable distribution.
It's qualified charitable distribution, or QCD. So that's off of your required minimum distribution.
So you'd have to be, you're either 70 and a half or age 75 if you're younger. So whenever they start forcing the money out of the IRA, that's when you're eligible to do the QCDs. One thing on the charity front, which is huge, that we have been working with select clients on, and that is being able to, either with your IRA or with outside assets, of establishing either today or at death something called a donor advised fund. This is, something that people call, I have a family giving fund. It works kind of like a foundation, only you don't have to have a board of directors and pay all the fees and do all the filing. But this donor advised fund, if you dump the money in, and it's during life, it'll grow, it'll grow, it'll grow, and you can make distributions from that to any qualified charity. What we're working with folks on is really increasing their charitable footprint. So if you think for every, for every X number of dollars, for every $1 million, say that you have, if you were able to, say, give a total of 3 million instead of 1 million, wouldn't that be a cool thing? If you dump that money into a donor advised fund, it earns a reasonably decent rate of return, and you elect a 10-year payout, your million's going to be worth 3. And the cool part is, if the charity knows, we all know about, fiscal responsibility and all these things, but if a charity knows in advance that they're going to get big payouts over a certain period, odds are they're going to be a lot more responsible with that money that they're receiving. The decisions that they are going to make are going to be probably a lot more along the lines of a strategic plan versus just a lump sum payout that we hope they do good things with. So that donor advised fund on an extended payout at your death can be it can be a really huge thing if you are at all charitably inclined. And one of the funny things is, I've had people that really, they don't really give away a lot of money, and maybe they're single, they don't have a lot of heirs, this sort of thing, and you're like, wow, for $1 million, I could do 3 million. That starts talking to you. So just give us just put that as a little mental note that this capability is there, and that at death, you could dump it into a vehicle, have that vehicle last, and really do something that you feel strongly about. You can truly leave the world in a better place.
Yeah, and another advantage to the donor advised fund, even during life, is the itemized exemption amount has increased so much. I believe it's 18,000.
Okay, so explain when you're saying that, because that's like gibberish to some people.
Right. So if you, when you file your 1040 return, if you itemize your deductions, your home interest, charitable deductions, or other expenses, to itemize, you have to list everything out. But they say now, but there's always been a standard exemption, but it was not very much. Now, I believe.
And you have to meet this threshold. If your stuff doesn't add up to over the threshold, then they give you a free amount.
Right. And I believe it's 18,000. I think it was 17, so 34,000. So unless you have over $34,000 in deductions, interest, charitable stuff, then giving money to charity doesn't really help you, except other than the that you're giving it and getting it out. But so people do what's called bunching. So you're like, okay, well, I want to give over the next 3 years, so I'm just going to take my stock and I'm going to give $50,000, and I'm going to take that $50,000 this year, and it's going to sit in the donor advised fund, and then you can tithe to the church, you can give to the charities or wherever you want it to go. And it has to be a 501c3 organization. So used to, people had the family foundations. There's several family foundations you'll hear about, but those were typically, they're very expensive to run. You have 990s, you have boards, you have fees, you have to give out a certain percentage every year. So this is a very easy, there's not much administrative cost. You're just putting it into basically a brokerage account that's a donor advised fund, and it's going to be invested, and then you get to choose who your donors are. And then you could also say at your death, I want my children to choose to give it away, or you could say, I want it all to go to the church or whatever you want it to go. And then you could, like Shari said, do it out over years or however you wanted it to do. But sometimes that's a good thing for families to do, to get, have children involved and making them be a part of awareness to give to charity and other causes. So
I guess today, one of the things that we wanted to do in talking about, what is probate, the components in the 4 documents that you need, some of the strategy pieces of all this, is really to encourage every single person that's here, to encourage our other clients, one reason why we're taping it, our beneficiaries, to have, some really needed conversations. Because sometimes it's really hard to, open up that line of communication. Oftentimes everybody wants to be confidential about their finances, and, not to say that everybody needs to know all the specifics, but if you're working with a holistic advisor like what we do, we really want to encourage you to have the individual conversations with that advisor, because then we can bring up the strategies of, which strategy may work best to have the money go further, longer. I have been told by a couple of beneficiaries, one of the best ways to open up this conversation, like especially if you have a parent that, they're holding their cards very closely, or if you are a close holder and you don't know how to really start the conversation. Oftentimes it's not necessarily just talking about, death. It's about, how do I want to spend my last years? And if, from an aging perspective, if we already know there's a rising cost of healthcare and it costs a lot to get old, you can wrap conversations around those type of things, maybe in a way that it just sort of bridges the gap between, okay, I want to talk about dying, as if you want to say, I want to talk about living. So just a little thought in that direction.
Yeah, and I've always said I will never leave a group without talking about elder abuse and exploitation. And I probably a month ago, I've had the worst case I've ever seen. I've seen a lot. I've seen $500,000 go out. I saw $250,000 go out. And the profile of the person who is being abused, the elder abuse is somebody in a foreign country, usually a man posing as a woman, or a man posing as a man to somebody else, or posing as Alison Krauss. Somebody recently was going to marry Alison Krauss, and went up to Nashville and met at Applebee's with Alison Krauss. And Alison was touring and she needed a soundboard, and so he had to send Apple $26,000 of Apple Music cards. So he did that. He was also giving money to a lady in Finland on an oil rig. Very smart guy. He was a nuclear engineer, and he said, well, I helped her solve the problem. She was on this boat, she was on this, and they had something, and they didn't know how to fix it. And I told her how to fix it. But she was working for a contractor, and she didn't have the credit card. So he sent Bitcoin, and Apple, $150,000. So he lost $250,000. He admitted it. But then I had a lady, and it's just awful. So this guy had been taken advantage of. So he's a widower. He's lonely. He's got women calling him. We're not women. And they're getting him to do all this stuff and invest. So they got him to invest in Bitcoin. So he sent $200,000 from here to SoFi to Coinbase to the crooks. So they showed him a statement that showed that he had made $70,000 in 2 months. And he's like, well, that's pretty good. It is, but it's not. So then he sold his business, or he sold the property. He had sold his business, so he sold the land. So he had where his business was. He had paid $450,000 in 2017. He sold it for 2.3 million or 2.1 million. He sent $2.1 million to Bitcoin, and it is gone. And he did it in February. He's still talking to the people. He knows he's been taken. So the FBI is now calling him. It's not the FBI. The FTC's calling. It's not the FTC. Well, if you give us 1.2 million, we'll help you get your 2 million back. So, and he still talks to him. He still sends pictures of him in his pool. And some lady said, "Oh, that looks nice and luxurious. I can't wait till I can come swim with you." My son had one the lady had sent to, there was a real cellist, and he's a young, good-looking cellist, and I forgot what country he's from, but he's world famous, because I had another client that told me, "Oh, I'm going out to see my son, and we're going to go see this cellist." I said, "Is that him?" But he is a real cellist, but these people pose. She sent him $500,000 to help him produce an album. And then, she was playing in Nashville, so they bought tickets for her to go see him, and they were going to go backstage, and he had the honeymoon suite at the hotel. And so she goes to she had a real ticket, why not give her, $100 ticket since she gave me $500,000. And so anyway, but he couldn't get backstage, and texting, I don't know, my manager screwed up, So anytime you get those, and you'll get them, they'll get in and they pray, and they're good. They're very good. I mean, this guy lost $250,000. His son knows it's a scam. He says it's a scam. And he goes in church the other day on Easter. He's texting the lady and sending pictures of the church. So be aware, especially, and be aware for your neighbors or your friends or your families, because people fall for this. And you wouldn't believe some of the very, very smart and intelligent with it people. I had a very successful client who was widowed, sharp as anything. She fell and she gave $40,000 in cash. And these Bitcoins, anytime you see Bitcoin, it's a scam. And I was on a call with AARP, and they had a bunch of legislators, kind of a task force. So there was a lady who went to a Bitcoin machine. You see them in Marathon gas stations. You see them in other gas stations. So she goes there 120 times a year, and she's feeding 1,000, 2,000, whatever in. She got took for 250,000. Last time she was there, she slipped, fell, hit her head, and died. So, but it is rampant, and it's hard to stop. I mean,
we've had several situations where the one was a Federal Trade Commission phone call, and I think these people find you if you're on some of these websites and you click, somehow they're finding your email address. But there were phone calls. And they sounded, completely legitimate, the Federal Trade Commission, but they were not going to call you. The same thing of, please, your computer's frozen, please pay us money. All of that is a sham. We have had relationship scandals where, someone is phone calling, emailing, "Oh, my family has an emergency. We can't pay for the surgery. Money comes out of our accounts. It's going, overseas." I think the other one that we got, and I would just say anybody that if you've got, friends that pass away, I guess there's, the bad guys are combing, the newspaper and the listings of all the deaths, because it just seems like, at least with our client base, as soon as someone dies, it is within 6 or 7, 8 months there that the attack happens. And, the person's, emotionally distraught. They're embarrassed that maybe they can't handle all the questions, and so they don't ask anyone. And we've had cash deposited in those Bitcoin depositories. We even had one that they posed as the bank. So they had found out where she banked, and there was some other piece of information that the scammer found out about, and they just kept calling her, and she kept, picking up the phone, and they said, "Well, it's just this thing. We can see your money. Everything's good, but we just need the money to go in one pocket, and then this pocket can get freed up." and it was a Bitcoin depository that they wanted her to put her cash into. So it's a tough, evil world out there. These scams are out there, and if we're talking about asset preservation and estate planning, unfortunately, this becomes, one of those topics that we have to
And
deal
no one
with.
will call you for missing jury duty. They will not call you, and and that's gone around like 3 or 4 times recently. And nobody calls you for your utility bill to go pay Bitcoin. But then the bad part about the guy with the 2.3 million, now next year he's going to have a $750,000 tax bill
Oh my goodness.
because he had capital gains. So,
Right.
So it's that was the worst I think I've ever. Well, that's definitely the worst I've seen. I mean, I've seen $500,000 and billions, or or less than $500,000 a lot of times, but that was the worst.
Thank you guys so much. We'll be around for questions, and thanks for coming.